Spousal support in Missouri. In my opinion, spousal support is probably one of the most complex areas in domestic relations practice. As a practitioner, it's extremely difficult, whether you're representing the payor of spousal support or the requesting party, to properly advise them on what to expect. When looking at the law, you might think that there are specifics that are provided in the statutes that help guide the practitioner in properly advising their client, but in actuality, the statute is not truly a roadmap when it comes to spousal support. It's really more of a checklist when it comes to the court's evaluation of a case. So the statute I'm referring to, which is the core statute regarding spousal support, is 452-335. In evaluating a spousal support case, the first thing the court would do would be to evaluate the case by examining the requesting party's property, whether they have sufficient property, including any marital property awarded to the requesting party in the divorce, to provide for their reasonable needs. And of course, reasonable needs is extremely subjective. The second part is the evaluation or determination of the requesting party's ability to support themselves through employment, and whether they are the custodian of a child whose condition or circumstances make it appropriate for the requesting party not to seek employment outside of the home. So from the perspective of the court, and when advising your clients, whether in evaluating whether the case that's been brought to you is a spousal support case, this is the first step the court's going to take in evaluating the case here in Missouri. The second prong of the threshold test in the statute as it relates to the evaluation of income or employability of a spouse, the court has the ability not only to identify, of course, what a spouse is earning, but in cases where a spouse might be underemployed or unemployed, the court has the ability to impute an income to that requesting party based on their credentials, education, licensure, background. The trial court's determination whether to impute income to a party is within its discretion, and the appellate court has again stated that they will not reverse a trial court's determination absent a manifest abuse of that discretion. Discretion is the aspect of a spousal support case that makes it difficult for us as practitioners to advise our clients on what to expect. Again, whether you're representing the payor or the requesting party, because of that discretionary authority, you can take, and I often tell my clients this, you can take the same case, the same evidence, and the same circumstances, try it in front of two different judges and get two different results. That's just a fact. And it makes it extremely difficult, which again goes back to my earlier statement, which is why spousal support cases are very complex in Missouri. All right, this is the second part of the statute, that once you've met that first threshold, you then move to the second step, which is evaluating the amount and to a lesser extent the duration of a spousal support award. There are 10 factors within point 2 of the statute. The first factor is examining the financial resources of the party seeking maintenance, including marital property, apportioned to him, and his ability to meet his needs independently, including the extent to which a provision for support of a child living with a party includes a sum for that party as a custodian. That second part of that particular part of the statute is oftentimes ignored, because the fact of the matter is child support considers certain expenses that a parent also benefits from. So a portion of those utility expenses, a portion of that mortgage payment, a portion of that car payment, those expenses are factored into child support, so they shouldn't be ignored when evaluating a spousal support claim. The second part, or the second factor that the court looks at in evaluating how much, and again to a lesser extent the duration of spousal support to be paid, is the time necessary to acquire a sufficient education or training to enable a party seeking maintenance to find appropriate employment. Reading that particular part of the statute on its face, it's easy to fall into the belief that if you have a requesting party who might be a student who is scheduled to graduate or accomplish their degree within a certain period of time, to use that as evidence to convince the court that a spousal support award should be term based on the completion of that education and a reasonable period of time to acquire employment, with, of course, a testimony presumably by a vocational expert to identify the type of employment that requesting party may be able to obtain once they've obtained their degree. That's not definite enough. So when you're arguing issues of education, training for the requesting party in order to become self-sufficient, the majority of those cases are going to end up being an open-ended, open-ended modifiable spousal support award. The third factor is a comparative analysis that the court must do between the earning potential of the payor spouse and the requesting spouse. Again, it makes it sound somewhat subjective, discretionary, and it is, and again, making it very complex. Those of us who've practiced and had spousal support cases know that we've presented cases to courts where, despite the fact the requesting party has a history of being perhaps a stay-at-home parent with a degree and some work history, one judge may believe it's time for that person to then go back into the workforce if the child doesn't, if there are children, if they have no reason or no condition that requires the requesting party to stay at home, while another judge may believe a spousal support is appropriate. The fourth factor that the court will look at is the standard of living established during the marriage. This is oftentimes a hammer that is often used by the requesting party to argue a larger sum in order to maintain a standard that the parties have enjoyed while married. Well, the first practical problem with that is that we are now dealing with the same income, but additional expenses because both parties will not be living in the same household. We're going to have two households being supported by one income. So theoretically, or practically I should say, it's not possible to maintain the same standard of living. However, the court has to consider that in assessing or evaluating how much spousal support should be awarded and for how long. The fifth element, obligations and assets including marital property apportioned to him and the separate property of each party. The responsibility for almost all or all of the marital debt would not preclude a court from awarding maintenance. It's a consideration, but it's not a preclusion. When the husband's ability to pay is balanced against the wife's striking inability to meet her reasonable needs, the balance tilts in favor of maintenance. The sixth of the 10 elements that the court looks at is, of course, the duration of the marriage. Logically, a long-term marriage, and although that definition of long-term marriage is not codified in any particular place, many of us have bought into the belief that maybe a 10-year or longer marriage might qualify as a long-term marriage. But that is not specifically identified as such, but that would be a better case or a stronger case for a party or a requesting party in a spousal support claim, which practically speaking is true, but there is no duration of time that a marriage must exist in order to qualify for a spousal support claim. The seventh factor is the age and physical and emotional condition of the spouse seeking maintenance. The eighth element is the ability of the spouse from whom maintenance is sought to meet his needs while meeting those of the spouse seeking maintenance. The ninth is the conduct of the parties during the marriage. Finally, the catch-all. Any other relevant factors? So you have 9 very specific areas that the court has to evaluate, and then you get to number 10, and then it's anything else that the court feels is appropriate, which is a broad standard and feeds into the difficulty we as practitioners have with attempts to appeal a lower court's or trial court's spousal support order. Again, buying into the substantial discretionary authority that the court has in making these decisions regarding spousal support.